Good afternoon and welcome to our third and final session of our estate planning and power of attorney series. Firstly, I'd like to acknowledge the traditional custodians throughout Australia and their connection to the land, sea and community. And we pay our respects to their elders past, present and emerging. For those in Sydney, hopefully you're looking good with a fresh haircut. And for us in Melbourne, it's only a few more weeks, so hopefully we'll be able to get out and I'll get this bushy hair cut. But today, we'll be discovering different aspects of power of attorneys and how they operate. And I'm pleased to be joined by Rahani Bixler from Burke and Associate Lawyers again, and Keegan O'Rourke from SW, who's a senior advisor in our wealth management team. As usual, our support team will be there to answer your questions through the Q&A function. The Q&A button can be found at the bottom of your screen. Please feel free to send questions that you have throughout the session using this function. We look forward to answering either straight away as we go, or for more complex questions, we might wait for the panel section later in the presentation, or come back to you after the webinar. We'll also circulate the slides to everyone who attends the webinar when it concludes. We've got today's first poll, and this should show up on the screen. And we're asking, do you have a power of attorney? And when was the last time it was updated? So as you answer that, I'd like to welcome our first presenter, Rahani, who'll be sharing her insights on power of attorney. So I'd like to hand over to Rahani now.
Thanks so much, Matt. So today we're talking about powers of attorney. And thank you everyone for joining us for this session. Now, sometimes, sorry, I've jumped forward a slide, I think. The first thing that we're just going through is what is a power of attorney, and having a look at some of these discussion topics that were outlined, I think, in the invitation. So what is a power of attorney? Sometimes people think they have a power of attorney when what they're really thinking about is the nomination of their executor in their will. There are very important differences between a will and a power of attorney. So primarily, a will only operates after you've died, whereas a power of attorney will finish upon death. So it operates while you're alive, but ends on death. Powers of attorney are state specific. So today we're primarily looking at Victoria, but interstate, they may be recognised if the documentation is fairly similar. But it is important to note that if you have assets in multiple states, you may be best to have multiple powers of attorney for each state. So the main thing that we're talking about today is the enduring power of attorney. But as you can see, there are quite a few different types of power of attorney. We're just going to have a quick look at some of those other documents before we talk about the enduring power of attorney, and more specifically, the financial enduring power of attorney. Our forms in Victoria were changed a few years ago, but if you do have documents that predate those changes, those will still be valid. Now, if we have a look at those forms, as you can see on the slide, many people think that what they're wanting is a general power of attorney, because notionally, they just want the power of attorney to be generally effective. Counterintuitively, a general power of attorney is actually very specific. So most people would use these, for example, to deal with the sale of a property or to manage a self-managed super fund if they're overseas. So there's a specific provision as to when it would come into play or what it could be used for. And it does not continue to be valid if you, as the person who's made that document, lose capacity. So your attorney nominated under a general power of attorney can only act while you still have the capacity to act for yourself. So this is why an enduring power of attorney is more commonly the preferred document. It lasts beyond your own decision-making capacity. If we just have a quick look at the appointment of medical treatment decision maker, this came into play in 2018, and it replaces what we used to just call the medical power of attorney. Under this document, you can only nominate someone to make medical decisions on your behalf, and they're successively nominated, so one person at a time. So the document could say A, then B, then C, but you can't nominate them jointly. And you can't outline on this document what you would like those medical decisions to be. So it's just, this is the person who gets to make them if I can't make them for myself. Only comes into play if you've lost decision-making capacity. If you've got really strong views about your medical treatment, it may be worth considering an advanced care directive. This is the document in which you can actually outline your directions for medical treatment or refusal of medical treatment. This document can include an instructional directive, for example, an express refusal for tube feeding, or a values directive, for example, I'd like to stay living at home regardless of the impact of the quality of care on my life expectancy. And we do recommend, because these are really medical decisions, that this be done in conjunction with your GP or medical practitioner. So then if we're having a look at the enduring power of attorney, this is the document in which you can nominate people to make either personal decisions for you, financial decisions, or both. And you can have different people to make personal versus financial decisions. In this document, you can have between 1 and 4 people, and you can have the flexibility to nominate them to act together. So they have to all agree, or by majority, say 2 out of 3, or successively. So A, if not A, then B, if not B, then C. You can determine in the document when it starts. So it might start as soon as I sign it, or it might start only if a doctor says that I don't have capacity for the decision. If you do still have capacity, you can revoke this power at any time. So if you don't like what someone's doing, or you'd like to appoint a different person, you can revoke it. But once you've lost decision-making capacity, you've lost the power to revoke. So you do need to be careful who you nominate and make sure that you're confident with how they're going to use the power, which is very broad. The power of attorney document can include specific powers, and it can also limit powers. For example, some people may have a power of attorney for a business that they run as a sole trader and nominate a particular person just limited to those business operations, for example. And you might have a different power of attorney to make other types of decisions for you personally and limit it to that. So you might have multiple documents operating at the same time. When you're nominating someone under a power of attorney, it's really important to, first of all, note that there are certain people who can't act in this role, and they're outlined in this slide. Once you've ruled those people out, it's a good idea to have a careful think about the type of power that you're handing over. It's quite substantial. So your attorney under power of attorney could sell your house, take all your money out the bank, basically deal with financial decisions on your behalf. They have these powers. They do have certain responsibilities, but they have the ability to really misuse that power. So you need to make sure it's someone who is trustworthy and who that you would feel confident would act in your best interests. Overall, there are some duties that a person appointed as an attorney has. So these are outlined in the slides. And if we think about these provisions, for example, not profiting from the position, you may want to actually make some specific provisions. So it may be that you would like your attorney to be able to charge for their services. And so that can be included. So even though as a standard, there are some things that they may not be able to do, have some specific limitations, you can override some of those by including specific powers. And some common examples, in addition to that ability to charge, is the ability to release superannuation. So for example, if you lose decision-making capacity and you're diagnosed with a terminal illness, you may want your attorney to be able to apply to the fund to withdraw your superannuation if otherwise it would be passing to, say, adult independent children who wouldn't receive it tax-free. If it comes out to you, you can get it tax-free and then it can go through your estate. So as long as the will is consistent with who you would want to benefit. Some people would like the attorney to be able to release gifts to family members or charities. And other times there might be specific limits that you'd like to put in. So for example, if your will deals specifically with a property, maybe gives a life interest to your partner for their lifetime, you may want to limit your attorney's power to deal with that property so that the provisions of your will can be upheld. As we said before, the power of attorney continues even if you've subsequently lost decision-making capacity, and it ends when the person who made the power of attorney dies, revokes the power, or if the attorney resigns or is removed by VCAT, and we'll talk a bit more about VCAT later. As we've seen, there are quite a few things an attorney can't do. It's important to note that an attorney can't change someone's will, which is a question that we're often asked. And we have talked about the importance of looking at including specific powers, but sometimes in that type of example, and these ones that are outlined, you can't override the ability of the attorneys. So the attorneys cannot do these things regardless of the provisions that you may put in the document. Now, if you don't have a power of attorney and you lose capacity to make decisions, so for example, you suffer from an acquired brain injury, you're in a coma, you develop dementia, this can create some significant issues. No one can automatically act on your behalf for financial decisions, even if assets are jointly owned. So if you have a think about it, if you jointly own your house with your partner and you were to unexpectedly lose capacity and you don't have a power of attorney, the co-owner of the house can't sell the house, can't refinance, can't rent it out without your signature, which you can't now sign documents that you don't have capacity to understand. So there is a way around this, which is an application to VCAT. And again, that comes later in the webinar. But having a power of attorney is a much easier option, and it does help avoid that VCAT process. Issues may also arise if you don't have a power of attorney and you have a business or a superannuation fund. And Keegan and Matt are going to talk a bit about those things. So I'm just going to hand over to Keegan now.
Yeah, thanks, Rahani, and thanks everyone for taking time out of your day to be with us. I want to spend the next couple of slides focusing in on powers of attorney within the superannuation context. As I'm sure we're all well aware, we have an immense retirement savings system here in Australia. As it stands today, there's about $3.3 trillion in retirement savings. For many clients, their superannuation account is the largest asset that they hold outside of the family home. So discussions around powers of attorney and superannuation are quite important to have. The next few slides should have some relevance for every person on this call that has a super fund, irrespective of how it's held, whether it be an industry fund, retail. We'll also touch on a couple of extra consideration for those who are trustees of a self-managed super fund. Okay, so to start off, I've put up on screen a range of authorities that a power of attorney might typically have. I won't go through these individually, but hopefully what you can see is that they range the full spectrum of interactions with your super fund, from day-to-day administration, be it altering a monthly pension amount or varying investment option, to significantly restructuring the strategy of an account. So roll into a new super fund or starting or stopping an income stream. The point of this slide is to reinforce the idea that your power of attorney has potentially the capacity to make significant changes to your circumstance. There are some changes that a power of attorney can make on your behalf that are straightforward and unlikely to create any obvious conflicts. And there are some changes that a power of attorney may exercise that will warrant further consideration from the super fund's trustees. So on screen, I've put up a common example of each of these. So the first one being changing the investment option. So we consider it's a common scenario where you're acting as power of attorney for mum or dad, and at the same time are arranging for entry into an aged care facility, for example. In that circumstance, it might be appropriate to move the superannuation account from equities into cash in the interim. Such a change is unlikely to create any conflict with the power of attorney because the power of attorney is unlikely to get any direct benefit there. On the flip side, your power of attorney may be able to change beneficiaries. So add a beneficiary, remove a beneficiary, or alter allocations between existing nominated people. And this sort of change has the potential to result in financial gain for the power of attorney, noting back to Rahani's slide that they have a duty not to profit from the position. So super fund trustees will need to consider, in deciding whether to allow or decline such actions from the power of attorney. They'll look to the power of attorney documents to see if they're expressly authorised or limited to act in such a way. As you can imagine, when dealing with superannuation and powers of attorney, there's a raft of overlapping legal and regulatory considerations that we need to navigate. With self-managed super funds in particular, we have the additional consideration that members also act as trustee for their super fund, either individually or through a corporate trustee structure. So what happens if a trustee of a self-managed super fund is taken out of action and we're seeking to rely on a power of attorney to act in their stead? Well, first off, we check in with the legislation. The Superannuation Industry Supervision Act, the SIS Act, is the main piece of legislation that governs super funds in Australia. The SIS Act states that your power of attorney is your legal personal representative, and your power of attorney is eligible to be appointed as individual trustee or director of your trustee company. Great. So now we need to go back and check our legal documents. For your power of attorney to act as trustee, he or she must be given the authority to make decisions about your financial matters. So this is where having a conversation with Rahani or your solicitor when drafting your power of attorney documents is so important, as your solicitor will help work through your individual circumstance and ensure that your power of attorney is given any specific authorisations that they require to help step into your shoes if you're incapacitated. Now, it's important, just because a person is granted a power of attorney, it doesn't automatically appoint them as the trustee or director for your super fund. So now we're going back to the legal documents again, and we're checking in with the self-managed super funds trustees. Now, each of these are slightly different, so you'll need to confer with your own documents to see what authorities you've been given, because it may be written that your power of attorney can automatically step in on your behalf, or it may require the approval of other fund members and trustees. So before everyone here who has a self-managed super fund rushes to dig out your trust deeds and look over the documents, what is it that you're actually looking for? On screen, I've put up an example clause. Yours may have something similar to what's on screen. In practice, the process of relying on a power of attorney for a super fund is, first off, to document the legal disability of a member in consultation with medical practitioners, the appointment of the legal personal representative in their place as trustee or director of the company as appropriate. As part of the appointment, the legal personal representative, your power of attorney, must consent to act as individual trustee or director. So they do have a right of refusal there. So that's important when considering who you're actually nominating as a power of attorney. It's also usual for a deed of appointment to be executed for the power of attorney to become trustee, unless they're already trustee of the fund. And depending on the situation, there may be other documents that you need to lodge with the ATO, the tax office, or ASIC. it's important for self-managed super funds that there's a general rule that each member of the fund is also a trustee of the fund or director of the corporate trustee. So if you're incapacitated and your trustee says that you can't act, it's important to have a replacement trustee put in place quite quickly. Luckily, the legislation allows a 6-month period for the fund to be corrected and remain compliant. So what happens to my super fund if I'm incapacitated and there's no power of attorney in place? As Rahani mentioned, your POA is something that you want in place before you need to rely on it. You can't go back after the fact to put one in place. In this situation where you need to rely on one and you don't have one in place, a family member or other concerned person may apply to the state guardian or in Victoria, the VCAT or interstate equivalent for the appointment of an administrator or guardian. That person doesn't hold a power of attorney, but is appointed as your legal personal representative who can then take your place as trustee. Now, this process can be quite costly, it can be quite drawn out, and it is probable that would exceed the 6-month time frame given by superannuation rules. So you may run into issues where your super fund is deemed as non-compliant, which can result in significant tax penalties. If your super fund has more than one trustee, your spouse, for example, that trustee may step in and take over your responsibility, but then looking after the fund as a whole, it may be best case that your assets are then rolled out into an industry super fund, for example, just to preserve the remaining assets within the super fund. Other uses for a power of attorney. So up until this point, we've talked a lot about if you're involuntarily incapacitated through illness or injury, but it's also important to note that you can voluntarily call upon a power of attorney to act on your behalf. Reasons why you might do that is, for example, you're traveling overseas or going bush for a period and you're not going to be contactable, or as it says here, other activities take priority. Okay, life gets in the way. There might be business decisions or newborns on the way that require more of your attention. Importantly, if you are leaving the country for more than normal overseas holidays, make sure that you check in with your accountants around the treatment of your self-managed super fund, because if you cease to be an Australian resident, there's tax considerations there as well. So in that situation, you might want your power of attorney to be a locally based trustee, just to remain compliant and not hit the penalty tax. Another consideration is if you're bankrupt. Unfortunately, in that situation, you can't have your power of attorney step in and fill your shoes there. It is likely in that situation that your assets will get transferred to a public fund, while you're insolvent. So hopefully there's a couple of points there to think about with your circumstance, and I'll hand over now to Matt to continue the conversation.
Thanks, Keegan. So I think we're going to share the results of the first poll. And as you can see, 80% of people attending today don't have a power of attorney. So that's even higher than from our estate planning. So in our estate planning, when we had 50% of people not having wills. So I think based on today's discussion, people might need to turn their attention to their power of attorneys. And as Rahani said, even if you're owning a joint asset, say just your main residence, you may need a power of attorney there to deal with that if something happened to your partner. So I think that's a really important aspect. What I'd like to talk about today is business structures and power of attorneys. And we're going to talk about companies first. So as Rahani said, it's important to note that a will is not a substitute for a power of attorney, including a company power of attorney. This is because the will only operates when after a person dies. So a company power of attorney can be used to ensure the smooth operation of the company after the death of a director, but before the executor has undertaken the opportunity to administer the estate. And there are a number of other reasons why you might want a company power of attorney, which we're about to go through as well. Important thing is to review your company constitution. Some of them allow for power of attorneys and some are silent. So you need to sit down and work out, well, what does my company constitution say? In relation to an individual shareholder, an individual power of attorney can be made, and the decisions can be made on behalf of the shareholder, where it's an individual shareholder, as they're acting on behalf of the individual shareholder, not the company. In the case of a director, a director will require a company power of attorney. So company power of attorney authorises a person or people to act on behalf of the company and sign certain documents on its behalf. Under Section 127 of the Corporation Act, it requires 2 directors or a director and a company secretary to execute documents. And the scope of a company power of attorney can be separated into 3 types. So you can have limited power for routine transactions. So this may be a company may wish to grant this limited power to an attorney to complete pretty routine things. Maybe it's getting certain bank documents or issuing invoices, and instead of having to try and get 2 directors to sign, it could be one director and a power of attorney. For specific purposes, so this might be where there's a large transaction going on and there's lots of moving parts to the transaction, and there might be pre-prepared board resolutions which mightn't have anticipated all parts of the transaction. And this allows for some flexibility, particularly say if a director went overseas during the complex transaction, but the company needed to urgently sign off on documents. And as we know, with some of these complex transactions, they can take 6-12 months. So, the directors may go on holiday or overseas for a period of time, and that this allows this transaction to continue on. And then again, the third is a general power. So a company power of attorney may be useful in case of unexpected contingencies, such as if a director dies or loses capacity due to illness or an accident. And so it allows the business to continue on until the succession plan can be put in place. In terms of liabilities of directors, it's important to note that a company's power of attorney is an agent of the principal being the director, and the director is still liable for the acts of the company's power of attorney. So you're still a director, you haven't ceased to be a director, but you've put someone in place to act on your behalf. In some circumstances, you may not want to do a power of attorney, and you may consider the appointment of an alternative director. Instead, a company director can appoint someone as an alternative director for a set period of time. This can include some or all of the powers that directors would have. An alternative director, if appointed though, can also act in their own right and does not have to act with the wishes of the appointer. So, you've got to weigh up the options there. The appointing director may stop the alternative appointment at any time. So if you appoint an alternative director for yourself, you can stop that. A company's power of attorney will be revoked on the dissolution of the company. So this could be on a liquidation of the company. The company power of attorney can also be revoked by resolution by the company's board of directors by signing a formal deed of revocation. The next structure I want to move on is to trusts, in particular individual trustees. I've got a table here which outlines the duties of trustees and power of attorneys. And in terms of trustees' duties, they need to act in the best interests of the beneficiaries. So they must obey the law, but subject to that, they must put the best interests of the beneficiaries first. The trustees must act unanimously if there's multiple trustees. So what that means is they must follow the trust deed and the decision-making rules. And any decision made by them is jointly and unanimously made. They must avoid fettering of discretion. Now, this is a legal concept, and basically it means they cannot make up another set of rules to follow. They need to act in good faith, so they need to exercise powers that are reasonable and relevant for the purpose. And they must act personally, so they can't delegate. And this is very important. And the rules on this differ from states. So in Victoria, New South Wales and South Australia, trustees cannot delegate at all. In Tasmania, Western Australia and Queensland, there's some temporary powers if a trustee was to travel interstate. The power of attorney's duties were discussed by Rahani earlier in the presentation. And I mean, I think one of the key ones is stand in the shoes of the principals with their best interests in mind. Now, when you look at that first one up there of trustees' duties, it says act in the best interest of beneficiaries. So we're acting for a group, whereas the power of attorney is acting in the best interest for one particular person. So a conflict of interest can arise there. So what you might need to do to override that conflict of interest is in your power of attorney, allow your power of attorney to enter into conflicted transactions. In terms of trusts and the appointers, again, like I said, with the company constitution, and when we were talking about estate planning, you need to review your trust deeds. Does the deed allow for a power of attorney to act, or is it silent? If it's silent, you may need to include an express authority to act as an appointer in your power of attorney. When a power of attorney loses capacity, things can get murky, especially if they have appointed an attorney who is also a beneficiary of the trust or a potential beneficiary of the trust. And the importance of the attorney selection in a case called Belfield and Belfield, which is a New South Wales case, was highlighted. In this case, a deed of appointment named Mrs. Belfield as the appointer of the family trust, and it gave her significant powers to direct the trustee of the trust on how to act. She developed a severe case of dementia, and it was questioned whether it was open for Miss Belfield's attorney, her son, to exercise her power of appointments on her behalf. And this case went through the courts in New South Wales, and on appeal, it was viewed that Miss Belfield's power under the deed of appointment did not amount to an authority to act as a trustee. However, it did allow her son, Charles, to exercise her power of appointment on her behalf. So it's important to understand who is your power of attorney and what powers they do and do not have. And in that case, the two brothers were disputing a property, and so one had the power of appointment but could not act as a trustee. In terms of partnerships, again, partnerships are usually a group of individuals who join together to form a business. And in those circumstances, you can use individual power of attorneys. However, you may want to consider having separate power of attorneys for personal matters and partnership matters. So you may, for your personal matters, may want your partner or spouse. And for partnership matters, you may want to have someone who you are in business with or a business advisor. So you may want to specify those in the power of attorneys. I'd like to hand back now to Rahani, who is going to go through the requirements about VCAT.
Thanks, Matt. So we've mentioned VCAT a few times during this webinar, and let's just go through a little bit about what VCAT is. So VCAT is the Victorian Civil and Administrative Tribunal. It covers a number of different things, but we're talking about the guardianship list at VCAT, so not fencing neighbourhood disputes or rental landlord tenant things. For when we're talking about powers of attorney and loss of decision-making capacity, we're talking about the guardianship list at VCAT, which is dedicated to hearing issues relating to a person's financial and personal matters. Now, the Powers of Attorney Act 2014 for Victoria sets out matters about which VCAT may make an order in relation to a power of attorney. So VCAT is sort of twofold in relation to powers of attorney. It can give orders or directions to someone who's nominated under a power of attorney, or investigate someone who may not be properly administering their power. Or if there is no power of attorney, VCAT may appoint someone as an administrator or guardian. So where there is a power of attorney, it may be the case that, like Matt talked about, there's a potential conflict and the attorney doesn't want to do the wrong thing, but they need to act. So let's see, for example, they might know that in the will, the person left a specific provision. You know, I give my car to my grandson, but they're not driving anymore. It's costing money in registration. They've lost capacity. Their attorney says it's not really in their financial best interest to keep the car and continue to pay registration, but I know that there's this specific gift in the will. In that case, the attorney may apply to VCAT for direction. What do I do? How do I deal with this to make sure that the person's wishes are upheld, but I'm also acting in their financial best interest? If there is no power of attorney, then VCAT is the port of call. So if a decision needs to be made and there is no power of attorney, then it's an application to VCAT for either administration, which is financial decisions, or guardianship, which is personal decisions. In both of those applications, there's two elements to the application. The first element is, does the person have capacity to make a decision? So medical evidence needs to be brought. And then the second element is there a decision to be made? So sometimes you may know of someone who doesn't have capacity anymore, but their affairs are all set up. Maybe they're already in aged care, their fees are being direct debited from their account, everything's being charged through the aged care facility, and really there's nothing that they need to do. There's no positive decision that they need to make. In that case, it would be difficult to get an administration order because things are ticking along quite smoothly without one. But where there is a decision to be made, for example, you know, mum's living in the house, she's lost decision-making capacity, she's falling constantly and in hospital, the house is going to need to be sold and we need to decide where she's going to live. The house needing to be sold is an administration order, that's financial. Where is she going to live? That's a guardianship order, personal decisions. This can be time consuming. There's some hoops to jump through, as you can see. So where you've got an obvious person, a partner or a child who you think this person stands out as the person I would like to make decisions for me, and I completely trust that they will do the right thing, a power of attorney is a better option, because then that person can just immediately start making those decisions, signing things off, and there's no real oversight other than, I say that, if they are doing the wrong thing and someone has suspicions, then they can lodge a complaint with VCAT and make some inquiries, and an investigation can be undertaken as to the attorney's actions. So if you don't have the power of attorney, an administrator or guardian can be appointed by VCAT. Now, if that happens and there's an administrator appointed by VCAT, there is a review process that it is an ongoing regular review where the administrator needs to report and account for all of the transactions that they've made. And if there is a significant discrepancy, think over 3%, and they can't explain the difference, they can be removed and VCAT can appoint an independent administrator. So an independent administrator is also often appointed in cases where there's no appropriate family member or friend, or the family members are in conflict. an independent administrator is likely to charge, but in some situations that is reasonable and it is a better option than having someone you may not, who may not necessarily be trustworthy. The process for a VCAT application can be quite onerous, and VCAT can't make a power of attorney. So if there is no power of attorney in place, or if a VCAT investigation determines that the attorney is acting appropriately, then the power of attorney will continue. We've talked a bit about the administrator. So the administrator is the person who is appointed by VCAT to make decisions about financial and legal matters. It may be limited to particular kinds of matters. For example, it may just relate to the sale of a house and the management of the proceeds of the sale, but it often applies to the whole of the represented person's estate. If more than one person is appointed, so sometimes VCAT will appoint joint and several administrators, then they are together the administrators. Now, as we talked about, the guardians make decisions about issues such as accommodation, employment, access to services, and access to the person. So sometimes there might be people who are distressing the person and who are not appropriate to be visitors, and a guardian can limit visitors. This can be really distressing when you've got family members who don't get along, and it is a good reason in that situation to really think about the power of attorney and have a clear vision if there are conflicting family members as to who you'd like to appoint. If VCAT gets involved and one of those family members is appointed as a guardian, it may have a huge impact on how that family interact in the future. Under the Act, a person has capacity to make their own decisions if they're able to understand the information relevant to the decision and the effect of that decision, if they're able to retain the information to the extent necessary to make the decision, use or weigh the information as part of the decision-making process, and communicate their wishes in some way. It may be gesture, it may be with the help of another person. It's not the capacity to make smart decisions. So just because someone makes a decision that we may not think is a wise one, doesn't mean that they don't have capacity to make decisions. And this is something that we do see quite often with parents who are worried about children going in or children who are worried about parents going in and maybe engaging in or taking up a terrible phone plan or something with a telephone provider, and they say, oh, you know, they're racking up these mobile phone bills, there's better plans, they should know what they're doing, and they're making really bad choices, or they're getting credit cards and they can't pay them off, or they're bad choices, but they're bad choices that a lot of people who still have decision-making capacity make. So you've got to go a step further and just, do they actually have the capacity to make a decision based on those things that I just outlined before. Once a guardianship or administration order is made, as I said before, it's reassessed regularly if it hasn't been revoked, but it's very hard to get out of. So essentially, if we have had matters where a person has lost capacity, for example, they've been under delirium, they've lost capacity, a decision needs to be made, an administration order is made by VCAT and there is an administrator in place, and then the person regains capacity and doesn't want someone else in there making decisions on their behalf, or wants to nominate someone else under a power of attorney. And in that case, again, we need to reapply to VCAT for the removal of that administrator and to show the medical evidence that the person does have the requisite capacity. In terms of the guardianship order in particular, an element of the decision making. It's not best interest necessarily. So under a financial power of attorney, the attorney needs to act in the financial best interests of the person they are appointed for. Guardianship, which is personal decisions, is somewhat different in that the guardianship order, and sometimes an administration order as well, promotes their own will and preference. So that's different from the will that operates after they've died. It's their wishes. So if you can demonstrate to VCAT that this person has specific wishes, you may be able to apply those wishes or undertake actions that may not objectively appear to be in that person's best interests. So that's, for example, like we were talking about before, under an advanced care directive, you might say, I want to stay at home. If you haven't got that advanced care directive, but you've expressed clear wishes to a VCAT appointed guardian that you want to be in the home, even if doctors are saying that's going to shorten your life or reduce the quality of care, the guardian can still make those types of decisions, but would need a specific VCAT order in order for that to happen. So Matt's just going to talk through a couple of other case studies that he has encountered in relation to powers of attorney.
Thanks, Rahani. Before I do that, I did note I skipped over mentioning the second poll, which is about business structures. And it's still open if you want to answer it. So the question is do you have a business structure? And if so, do you believe your current power of attorney is appropriate for the circumstances? Now, based on the current number of answers we've got, for those that have business structures, approximately a third are saying that they're appropriate. Another third is saying that it needs to be reviewed, and approximately another third are saying they don't have any power of attorney for their business structure. So again, I think looking at that, 2/3 of people that have business structures need to sit down and think about their power of attorneys. What I want to talk about are a couple of case studies. The first case study is something that's quite common, we see quite often, and it's where where grandma pays the school fees for the grandkids. She no longer has decision-making capacity for one reason or another, and the question is can the power of attorney continue to pay the school fees from grandma's funds, knowing that that's what she would want? Well, the answer is no, because the power of attorney needs to apply that attorney for the best interests of grandma, and paying school fees for grandchildren is not in that case. So what would need to happen is that the power of attorney would need to specifically say, before grandma lost her capacity, she would need to say in a power of attorney that if something happens, I would like my grandchildren's school fees to continue to be paid. And that way it's authorising the power of attorney to potentially enter into a conflicted transaction without the need or approval of VCAT, which is Victorian based. The second case study is in regards to a circumstance where a person, John, has a significant amount of cash in his own name, and he again loses his decision-making capacity. And the power of attorney is thinking, well, we might want to invest this in a family trust and invest it in the trustee's name. And it would be tax effective. We could use the discretionary trust. It would provide some asset protection. And again, the answer is that the family trust couldn't be set up in those circumstances, and the transfer of cash across to that trust happened. This is because, again, it would be a conflicted transaction. You know, potentially the attorney might benefit from the family trust being a beneficiary, or other family members may benefit from the family trust being a beneficiary. So it's not there just for John, who's the who's the principal person. Again, if John wanted to, he could put details in his power of attorney, giving his power of attorney the okay to set up a family trust or to invest those funds should something happen to him. But again, that needs to happen before he loses decision-making capacity. So what we'd like to do now is go through some Q&A, and I've got some questions here that first of all is for Rahani, and it's Rahani, where should a power of attorney be kept, and who should have a copy of it?
Great, thanks, Matt. People are very different in their wishes about this, but basically nobody wants to see the original power of attorney. If you ever need to use it, a certified copy is what is required. And so keeping the original with, say, the lawyer who prepared it is the easiest way to be able to obtain certified copies when they're needed, because the lawyer can photocopy it and certify those copies. They've got the original on site. You don't need to track down where it is. It's a good idea if you're comfortable to get your certified copies when you first have the power of attorney signed, and maybe keep one for yourself and one for each of the people that you've nominated if you're happy for them to have that straight away. Some people would prefer not to have their attorneys be given copies until they have lost capacity, for example, and the attorneys are able to prove that. But that's a personal choice. A lot of people do like to give their attorneys certified copies so that they've got them there ready when they need them.
Okay, thanks, Rahani. So I've got another question here. So if a person is a director and the power of attorney comes into effect, what happens to that position of the director? So the position remains in place as it's a personal appointment, but the person who has become incapacitated and cannot act really should be removed as a shareholder. And this might be beneficial because for asset protection reasons, because obviously that as a director, you're still liable, but if you lost the capacity to make any decisions, really you shouldn't be a director anymore, and the shareholders should pass a resolution to remove you. I've got another question here, Rahani, for you, and it's, if I hold an overseas asset, will my power of attorney in Victoria be effective?
I think you had a good example for this, actually.
I do, actually.
As I sort of mentioned early in the piece, even interstate, you might have some issues. That's going to be exacerbated overseas. So powers of attorney are state-based, and they might be recognised by other countries if the form or the requirements are substantially the same, but you definitely couldn't rely on that. I would recommend that you have the appropriate document in the relevant country or other jurisdiction.
So I have a very live example of that, where we have a client who has lost capacity and did have a power of attorney in place, which is in Victoria. That client inherited property over in the Czech Republic after she became incapacitated. Unfortunately, the Czech Republic didn't recognise the power of attorney here in Victoria. As a result, they needed to go to VCAT to get VCAT to approve the power of attorney to deal with the property in the Czech Republic and meet the requirements of the Czech Republic. And it has cost a significant amount in legal fees. It's looking upwards of $100,000 to sell this property in the Czech Republic because there wasn't a power of attorney in place for the overseas jurisdiction. Another question's just come through, Rahani, and it's if I have an enduring power of attorney, do I need to lodge it with or notify the bank at the time of preparation, or only when it's being used?
Yeah, great question. And again, that's going to be a personal choice. So when you do the enduring power of attorney for financial decisions, it may depend on when you want it to come into play. So if you nominate that it's effective immediately upon use, you may choose to lodge it and notify the banks immediately because you're happy for it to be used straight away. Whereas if you have an enduring power of attorney for financial decisions that you only want to come into play when you've lost decision-making capacity, then you'd probably wait and it would be lodged with the bank by the attorney with the medical evidence of loss of capacity. Okay. Sorry, did you see that other one there as well?
Yes.
About the power? Sorry.
Yeah, there's one more question here, and it's quite often partners or spouses would be listed as an enduring power of attorney and are likely also to be a beneficiary of the estate. They would be seen to financially benefiting from the decisions. Does this mean it's better not to have someone that is part of your estate for your enduring power of attorney, or is there another way around it?
Yeah, great. So there's a couple of elements there. The first is that while you're the attorney under a power of attorney, the person you're acting for is still alive. So you've got to act in their best interests. And whether you're a beneficiary of their estate ultimately or not is not particularly a conflict at that point in time. However, there are often conflicts with partners and spouses. For example, you might be looking at, you might have one partner who owns the house in their name and their spouse is living in that house rent-free. And obviously the intention would be for that to continue. But if that person is the attorney, they are getting a profit, being rent-free accommodation on where the attorney, the person they're acting for could be charging rent. So we do include or recommend that you include in a power of attorney an express provision that conflict transactions for a partner or spouse are allowable, provided they are still acting in accordance with your best intention, your best interests as well. So hopefully that answers that question. Good one.
And we've got one final question we'll do, and it's a little variation on one of the case studies that I presented on, and it's if a person has cash assets and there's already a trust in place, can the power of attorney transfer the cash to the trust without going to VCAT? And I'm happy to answer that. And that the answer would be, well, the transfer to the trust would not necessarily be in the person's best interests. There's obviously other beneficiaries of that trust that could benefit from the money. So it could be seen as a conflicted transaction. So unless the power of attorney states prior that transfer can happen, I would suggest that the answer to that is no. So I think that's all the questions we have for today. So I'd like to thank everyone for attending. We've gone through 3 webinars in this series on estate planning, succession planning, and power of attorneys. I'd really like to thank Rahani and Keegan for today, but also in the background, Stephen, Robin, and Taylor, Heather for presenting at the second webinar, and a big thank you to Lucy and Madeline from our marketing teams who have helped us get this done. If you do have any further questions, don't hesitate to send them through, and there will be some feedback on the session, so please complete our feedback survey, which will pop up at the conclusion of the webinar. And I'd like to thank everyone and look forward to catching up with you soon over the next few months when we get out of lockdown. So thank you very much, everyone.